And after Croatia and Serbia, we are moving a bit of northwest, and we have here Matthias for Austria and Žiga for Slovenia. And I assume Matthias will start the part for Austria.
Yes, this is just an alphabetical order, right? I'm very happy to meet you again. Good morning from Vienna, from rainy and cold Vienna. As we see, technology and the pandemic are changing the workplace, obviously, because I can't remember that we ever had a webinar in our firm, but we had a number of client events. All those client events stopped in Vienna. My last client event was early this year, even last year, I can't even remember. And now we're together again via webinar. And I think this is just a symbol of how the workplace, how the life of all of us has changed in recent months. So my topic will be to explain a little bit what I believe, what is the situation in Austria now, and how it will impact the future rules of work in Austria. I won't look back too much to the situation in March and April, which was very unsatisfactory in my view, but rather talk about the present and the outlook for the next month and beyond. And in this regard, I have three topics. The first topic is the current status of Austrian legislation. Second topic, what does this mean for employer? What lines of action should you take? What's happening? What should you do? And the third point is some outlook, what will happen after the pandemic and what will stay of all those changes we are facing at present. So starting with the first section, Austrian legislation. And there's quite an important difference between Austrian legislation and, just as I found out yesterday when we had some kind of preliminary discussions on these topics, the difference between Austria and many neighboring countries in our region is that Austrian legislation on many aspects, like homework in particular, but also on restrictions to business, is still pretty liberal in comparison to neighboring countries, which on the one hand means there's less kind of orientation what you have to do, but much more leeway to make your own policies and make your own rules within a rather comparatively lenient legal framework. This, in my view, is the central message. It seems Austria is less bureaucratic in these areas than many others. Why is this? First of all, Austrian COVID legislation, in particular the new legislation, is different from what it seems, less restrictive than in other countries. It makes it almost impossible for the state to interfere into private rooms, which means that you still can invite 100 people in Austria to a private party and infect everyone, which you can't in many neighboring countries, while you cannot do it in, for instance, in restaurants and gastronomy, which some people believe is unfair. But legislation decided to protect the private space in a very strong way, and in a very surprisingly strong way, even in comparison to neighboring countries, for instance, Germany. Second, there are very limited COVID rules to businesses other than for customer areas. So there's a number of restrictions applicable to entering public customer areas like shops, but also our meeting rooms, for instance. This is completely different for office spaces. So the office space, just the workspace without any customer in. There's only one rule, basically, which is the 1 meter distance rule. And 1 meter isn't really a safe distance, it's not even a far distance. So it should be easy to comply with this 1 meter rule. And even it's allowed to get closer than 1 meter if there are other protective measures like room dividers or whatever. So also this isn't really a strong restriction to business. And finally, the lockdown in Austria, the total lockdown has been restricted by law now in a way that it can only be ordered if the government complies with its own legislation, which might not be sure at all points in time. But if they comply with the legislation they brought into parliament and that was adopted in parliament, the lockdown in Austria should happen only if there's an imminent health crisis. So only if there's a real crisis of the health system threatening, then the government should order a full lockdown similar to what it did in March and April. And this means there's quite some leeway still for business, for people coming to the office or working from home. There are hardly any restriction. The only exception is there are rules for those that should be protected for risk groups. Those workers which are at special health risk could apply for so-called COVID certificate. Then they would be entitled to a paid leave. And this paid leave leads to a reimbursement claim of the employer in relation to the state. And because the state finally compensates for this, there's some restrictions. And now we get to home office. One of the restrictions is it is not this right to paid leave connected with the compensation by the state does not exist if the employee could do his work from home. Or alternatively, if the employer can arrange the working conditions at the workplace in a way that any risk of an infection with COVID-19 can be excluded by as much certainty as possible. And only under these conditions, if this cannot be granted, the state will also take over the compensation of the employee. And this certainly has an impact in several areas. What does this mean in particular for the risk employees at risk? Home office, again, no legal framework. In Austria, no special legal framework apart from some general rules, which also means that the conditions for homework can be agreed between the parties of the employment contract and in a homework agreement. Again, different to other countries, all we have is a general rule that the place of work needs to be defined. There are rules that in principle an employer should compensate an employee for the cost or related to reimburse for expenses related to work. But this is not mandatory and it can be again changed by way of agreement between the parties. And there's some rights of the Works Council if the employer wants to unilaterally change the place of work, if it's for worse for the employee. But basically that's the framework, and within this framework, employees and employees can act and can agree on home office and also have a certain influence on agreeing on the other working conditions. So that's the general Austrian legal framework on those topics we talk about today. I'm not talking about subsidies for short-time work because this is something temporary and the conditions change all the time. But basically, these are the rules. This is the basis in Austria. And now, second step, on the basis of this, what does this mean for an employer? Two different areas. The one area is protection of workers. So this is the aspect which is particularly relevant if you want to bring your employees which belong to a risk group back to the office, which some clients are trying to do because home office in some areas still proves to be difficult. So then the law says, okay, if you can introduce protective measures which sufficiently protect these employees, then they have to get back to work on request. Now, the question for every employer in Austria is who faces this situation, when can I be safe? So what kind of measures do I have to implement to make sure, on the one hand, that people don't get infected at the workplace, but second, on the other hand, that I try my best and I use best efforts to get them back to work if they can't do home office, because otherwise I wouldn't be entitled to reimbursement of costs from the state. And the basic question is it sufficient to comply with these very liberal rules on office work? Is it sufficient to say, okay, I can guarantee 1 meter distance between everyone, and at every time the distance gets closer, I have a room divider or whatever? Is this sufficient or isn't this sufficient? Well, in my view, this in particular for the risk groups would not be a sufficient standard of care applicable to those protected workers. At least there would be a risk that if someone gets affected and sick, that there might be liability claims. So probably the best standards you can get are those published by the Austrian Health Insurance Agency, published at their homepage. So in particular, if you believe you want those employees back to work, then probably you need to take a look at this and try to implement these security measures as recommended by the Austrian accident insurance agency. This should be a standard which is reasonably safe. For all other employees, in my view, it should be sufficient to comply with the general legislation. If the law doesn't require more than 1 meter distance, and this is a special legislation applicable to offices, I don't see why a liability of an employer should arise if someone gets infected, if the employer does uses his best efforts to comply with this 1 meter distance requirement. So that's health and safety. And the other area you should look at presently are the employment contracts and the home office agreements. As mentioned, there's a lot of leeway. But on the other hand, certainly if you agree on a place of work, let's say in Vienna, and the employee lives outside of Vienna, you could not order him unilaterally to do homework. This requires the consent of the employee, generally speaking. Same even if you agreed on like place of work is Vienna, even this is not safe. Some scholars argue that when signing a general clause that the place of work is Vienna, an employee would not commit to working from home. So there seems to be a tendency, not cleared by the courts yet, a tendency in literature that you have to agree on home office. And if you don't agree on home office, there's no obligation of an employee to work from home. Certainly also there's no right of an employee to work from home, which means, again, this is subject to an agreement. And this brings me to all those issues which were mentioned before for Croatia and Serbia. They're not required in Austria. You cannot be punished for not having a home office agreement in Austria, but certainly all these aspects like cost compensation, who provides which kind of materials and so on, and need to be covered probably to reasonably get the consent of employees to home office. And which is why probably a home office agreement in Austria should not look too much different from the other countries mentioned before. One aspect for home office to be considered is accident insurance. And there, I forgot to mention this, we do have legislation in Austria. So presently, for the time being, it's pretty safe that even if you get a coffee in your home office and burn your hands while working with hot water, you're protected by Austrian accident insurance. This wasn't clear before. And interesting enough, there are political discussions about whether this should be extended as a permanent legislation, because from the side of those financing the accident insurance, in particular employers, they believe that now accident insurance could become too broad and to cover too broad area of accidents at home. Which is, by the way, also one of the reasons why discussions between social partners on rules for home office have ended in kind of a deadlock at present, and it seems they continue, but still one of the areas of disagreement is how far accident insurance should go.
Well,
so,
thank you.
Matthias. Yeah, I'm over, and I'm over time, right?
A bit, but if you have something to say, just please go ahead.
Okay, now I'm almost done. Just mentioning one thing when agreeing on a place of work and on remote work. One of the things to be careful with is don't allow employees too much freedom. We had one case of an employee who was on remote work. The employer allowed remote work from every place, and suddenly the employer detected that the employee was working from Germany, which if someone does, it might have an impact on social security and tax legislation, which came quite as a surprise to the employer because the employer didn't even know that the employee worked from Germany, from outside Austria. So please be careful with granting too much leeway. The border is closed. And if you have employees from Slovakia, Hungary, Czech Republic, or so on, they might be inclined to simply return home and do their home office work from there, which then might mean that they are subject to social security and tax in their home countries. So this is something that should definitely be prohibited and prevented when setting up your policies. Yeah, that's basically it. The outlook in my view, just two sentences. Contractual rules on the place of work, home office will become also something that remains in the future. And the question, what kind of standards employers should apply to protect the health of employees, will also become much more important in the future. I think we will move away from the situation as it is now that everyone is responsible for his own health. And this will be a tendency to be observed during the next years. So thank you. Sorry for being so long. I'm open for questions. Thank you for listening.
Well, Matthias, thank you again. The time frame is indeed a bit short, but the topics are pretty interesting. So I actually hand over the word to Žiga to see how Slovenia is tackling with all these situations and obstacles. Okay, it seems that we are encountering some technical difficulties. And before, in order to repair that, I actually want to make some changes. Matthias, one question arrived in connection with the home safety insurance. Does it mean that the parties are compulsory should have this insurance policy, or this is something which is based on the parties' agreement or the employer's decision to have one?
At present, state accident insurance, so the normal accident insurance, should sufficiently cover accidents at home when the employee is working in his home office. So this is one of the few areas which presently you do not agree with them, have to agree with employees and to cover on an individual basis, because the general understanding is that the state accident insurance covers this, at least at present. Question for the future outlook: will we still have rules in place which are sufficiently clear and broad enough to cover all these accidents? If this is the case, if yes, then probably you don't have to care about this in the future either. If this isn't the case, and if they don't come to an agreement, it might be an important topic to enter into an additional accident insurance for employees while during the home office. For the time being, the answer would be no, I wouldn't cover this issue. It should be sufficiently covered by the state.
Žiga is here with us.
Yes. Hello, Nabash. I hope you can hear me now.
Definitely, loud and clear.
Okay, thank you very much. My apologies again. Apparently, no technical difficulties can ever be avoided regardless of the preparations. So basically, from the perspective of the Slovenian legislator, the terms working from home, remote work, and sometimes called flexible working arrangements, the three terms are quite indistinguishable. And during this year, this was easily the most hotly discussed topic in Slovenia, and to no one's surprise, not only in legal journals. Slovenian labor law does allow for remote work, but as was shown by the epidemic pretty well, was that putting it in place is in practice a very burdensome exercise. Well, at least as long as the employer wants to be compliant with the law. These bureaucratic hurdles are usually quite well known to employment experts, so we'll just briefly set them out and then in the following touch upon some less frequently discussed topics, which will probably be of most interest. Now, following the epidemic, many employers who had positive experience by allowing their employees to work from home would now like to expand the practice of homework also to the circumstances outside of the epidemic. We've also heard of cases abroad, especially in places where real estate is quite expensive, that employers are actually deciding on abandoning the usual offices and implementing homework as a rule. But of course, contrary to the times of the epidemic, and similarly, as applies in many countries, including, as we heard from Mariana, also applies in Serbia. Now, the employers cannot just simply instruct their employees to work from home, but must reach an agreement with employees to this effect. And as many have now learned, a mere annex does not suffice. Rather, a new employment contract must be concluded, which, especially when it comes to employers employing more than just a few employees, is quite unpractical and very likely to cause completely unnecessary suspicions on the side of employees. But perhaps even a more annoying requirement, but certainly more expensive one, is the requirement that a health and safety at work assessment has to be performed at the location where the employee will work. A health and safety professional must thus visit the employee at home and see if the work cabinet, kitchen, or the bedroom, or wherever the employee will perform work allows for a safe working environment. And a very interesting issue was already flagged by Matthias, and what happens when an employee is actually working outside of the premises which were initially envisaged by the employee and the employer. So for this reason, the contract must be quite strict and not allow employees too much leeway to decide where actually they will perform the work. And the last formal requirement, before the work commences, the employer has to notify the labor inspectorate. No consent of the labor inspectorate is prescribed, though. So those are the three issues which are usually most hotly discussed and frequently mentioned. But they are not all that employers should consider when agreeing or considering whether to agree with employees to allow them to work from home. Some practically quite important issues are in practice very often missed. So let's look into them. First, privacy and data protection. But this time, let's not be focusing just on employees' privacy, but rather on the legitimate interests of the employer. Employers are otherwise very well aware of the problems which the bring your own device policies caused. Basically, it means that the business documents and information are leaving the safe boundaries of corporate networks and enter the open, unsecured domain of employees' domestic equipment. IT departments will usually already have in place special applications which will allow for remote administration of employees' devices. And many employers will also only allow the employees to connect to the corporate network via private virtual network services, or even mandate use of remote desktop services. But all of this still leaves one giant security concern unaddressed. What can happen with paper documents? The significant other, perhaps a kid, or in practice, most likely a dog, can easily fetch any document which is left at home and carry it outside for everyone else unauthorized to see. Or perhaps a family member may read a privileged piece of information while just standing behind the employee, or perhaps just passing by. And those concerns naturally cannot be resolved by the IT department or specialized software. What needs to be done is that those issues have to be discussed with employees, and employees also trained in appropriate handling of materials at the premises where they work from. But of course, we still can't leave employees' privacy concerns completely aside. Not all employers actually provide their employees with mobile phones and laptops. Call forwarding in particular, forwarding of calls to employees' private phones is a huge concern. Employers should enable employees to call back customers and other counterparties or partners without, in the process, having to disclose their own private phone number. This is not only a privacy concern, and if an employee would be contacted by their employer's business partner outside of the business hours on his or her private phone, in a very bad scenario, such employee would be in a very good position to claim payment of overtime for the work performed during such a call. And of course, this is without taking into consideration all the other issues which could still be flagged by the employee if there ever was a dispute with the employer. Moving to the next topic, which was already mentioned by a couple of our colleagues. Employees working from home are entitled to a compensation for use of their own assets. Under the labor law, this compensation is a right of an employee. Still, it needs to be defined more precisely in the employment documents. Usually, the employer will provide some compensation for the use of employees' personal computer, private phone, and occasionally we've seen even internet connection. But there are also other costs which can in part be attributed, at least partly, to the fact that the employee works from home. For example, heating costs and other utilities. And finally, there is a third category of costs which incur independently from the fact that the employee works from home, but at the same time, the employer who allows or even mandates its employees to work from home may actually be benefiting from the reduction of similar expenses. For example, garbage disposal, fire insurance, rent for the lease of the apartment, or even amortization of the construction costs for the employee's house. Now, surely at this time, the issue of costs is a relatively undeveloped one, especially, of course, in court practice. But the more that the employers will push for employees to work from home, and the more that the homework becomes prevalent, the more we can then expect that employees, at least on their behalf, trade unions, will start pushing that employees are also reimbursed these costs. Or perhaps to put it more directly, or perhaps in the words of trade union representatives, employees should get their fair shares of savings realized by their employers. But with relevance as of today, if properly determined, the compensation of costs to employees can be tax exempt. So, but in the interest of time, let me not get into this issue too deeply. Rather, let's touch upon the last point. Recording of presence and measuring employees' performance, which was already a subject to one of the questions. The more that the arrangement between the employer and the employee allows the employees to flexibly organize their daily work outside of the 9-to-5 routine, the less clear the boundaries between work time and private time becomes, and the fuzzier the employee's effective rest periods. This, in consequence, leads to a significantly increased risk of overtime payment claims. And as we know, with respect to regular employees working in even distribution of time, payment for overtime cannot legally be waived, even though many employment contracts try to include a provision to this effect. It's true that the law requires that any overtime is specifically instructed to employees in writing, but the court practice has already confirmed that this is not a precondition for a claim of an employee for payment of such overtime.
Well, Žiga, thank you. Final thoughts before the questions.
Yes.
We have one question. Matthias already answered. The question is both for you and for Matthias, but I'm willing to hear your thoughts on that. We saw yesterday the announcement in the UK that the ambition is to support businesses also in the midterm to avoid collapses. So salary subsidies and transfer of fixed amounts directly to the employees. So the question is that, do you have any information that Slovenia will follow the similar pattern like the UK, helping businesses in that way, so transferring money directly to employees?
No, we, on basis of the past practice, we do not that the legislator would adopt similar measures. What we are seeing, in fact, is basically that the government tries to help the employers and, of course, consequently also employees in keeping their jobs. But what we are seeing is that the measures are usually being adopted at a very short notice, relatively short periods of validity. So right now, a new law is pending at the National Assembly, and certain parts of it will apply retroactively from the 1st of October onwards. And as we have learned in the past, it's quite possible that many of those measures will in fact be expiring by the end of the same month, being October, unless, of course, longer application periods are agreed upon or subsequently amended.
Thank you.